Welcome back everyone to the review of the 1 to 4 family residential contract for resale. Today we're going to go ahead and take a look at paragraph 6 title policy and survey. Let's go ahead and jump right into this one. This one's fairly long in and of itself. So the very first section that we're going to review is section A. This has to do with the title policy itself. And as in the previous videos, we're going to go ahead and read through it. Then we'll go back and kind of go over some highlights. So 6A states title policy. Seller shall furnish to buyer at either seller or buyer's expense an owner policy of title insurance, known as title policy, issued by blank title company in the amount of the sales price dated at or after closing, insuring buyer against loss under the provisions of the title policy, subject to the promulgated exclusions, including existing building and zoning ordinances and the following exceptions. So before we jump into the exceptions, let's go over this real quickly. So the title policy, who pays for the title policy, is a negotiable item in the Texas 1 to 4 residential contract. So either the seller can pay for it or the buyer can pay for it. In most circumstances, it is common for a seller to pay for a policy of title insurance for the buyer. However, in certain situations, such as multiple offer situations or where a buyer is attempting to make their offer more attractive, they can offer to purchase their own title insurance, in which case the buyer's expense would be an acceptable box to check. It just kind of depends on your situation, but I would say across most major metros in the state of Texas, the seller pays for a title policy in a regular non-multiple offer situation. The next blank is who's going to be issuing the title policy. Now, there's a lot of discussion about this and there's some varied opinions, but in the state of Texas, we only have a handful of true title insurance companies. Most of the companies we use in our local metros are not the company that issues the title policy. They are a forward-facing branch of a title insurance company, but they are not the actual company that provides the title insurance. There are some exceptions to this, but generally it's accepted that if you place the title company that you are closing it in this blank, that is acceptable. Now, keep in mind, it is totally legitimate to close at one title company and have title insurance issued by a different title company. That is acceptable, although it is not common practice. So, who's paying for it? Who's issuing it? It's in the amount of the sales price. It's dated at or after closing. It insures the buyer against loss under the provisions of the title policy. So, a title policy will protect usually against the chain of title, right? Does the person selling it have the right to sell it? And certain other items. Now, there are some exceptions, standard exceptions to this policy that you cannot go ahead and file a title insurance claim if one of these happens. A title insurance policy is similar to an auto insurance or a homeowner's insurance policy in the sense that if there's an issue that pops up, all you do is make a claim to the title insurance company and they process the claim. Now, let's jump into some of these exceptions. The first one states restrictive covenants common to the platted subdivision in which the property is located. Number 2 states the standard printed exception for standby fees, taxes, and assessments. Number 3 states liens created as a part of the financing described in paragraph 3. 4 states utility easements created by the dedication deed or plat of the subdivision in which the property is located. Number 5 states reservations or exceptions otherwise permitted by this contract or as may be approved by buyer in writing. Number 6 is the standard printed exception to marital rights. 7 is the standard printed exception as to waters, tidelands, beaches, streams, and related matters. Number 8, which we'll come back to, states the standard printed exception as to the discrepancies, conflicts, shortages in area or boundary lines, encroachments or protrusions or overlapping improvements. And I'm going to skip the next 2 portions. And number 9, the exception or exclusion regarding minerals approved by the Texas Department of Insurance. So these 9 things all show up as standard exceptions on a title policy. Now, it's beyond the scope of this video to go over a title policy in detail and point out each one of these things. But if you've done a deal, if you go back and look at the title policy that your buyer was issued, or maybe you have a title policy from when your seller bought the property, if you go and look inside of that policy, you will see all of these exceptions sitting in section B, or schedule B, of that title policy. Now let's revisit number 8 for a second. Number 8 states the standard printed exception as to discrepancies, conflicts, shortages in areas, or boundary lines, encroachments or protrusions, or overlapping improvements. And then there's 2 boxes, all right? The first one is will not be amended or deleted from the title policy, or number 2 is will be amended to read, quote, shortages in area at the expense of, and it's a buyer or seller payment. It is a negotiable option. Now, in the past, we did not have an option for whether the buyer or seller paid for this, which created some difficulty for the title companies to determine who's supposed to pay for it because it's not agreed upon up front. So now it's a negotiable item. I recommend in almost all circumstances that a buyer select the second option, will be amended to read shortages in area. And I usually, for myself personally with my clients, mark at the expense of the buyer because this has historically been a buyer expense. The cost of adding this coverage is 5% of the title policy amount, so it's not very expensive. Now, if you want to put seller on there, try to get the seller to pay for it, not a big deal. I'm only speaking from my personal experience and the way I handle things, but when I go ahead and work with my buyers and we go over the contract, I usually recommend that they just pay for this coverage. It benefits them solely, and it's really not an item worth fighting over, and it's much better to go ahead and use our goodwill to negotiate other items in the contract. Now, why is this particular section so important? If you select number 1, will not be amended or deleted from the title policy, if there's an issue with the boundary line, all right, like a dispute between neighbors about where the fence sits, or they claim that one sliver of land is supposed to be theirs compared to what you thought it was, if you don't provide an amended section for this, if you select number 1, then you're not going to be able to file a title insurance claim and have the title insurance company help you out with this. It's just going to be you versus, or I'm sorry, not you, it's going to be your client versus the neighbor, and they're going to fight it out without any help and out of their own pockets. Should you go ahead and opt to select number 2, will be amended to read shortages in area, if there's a boundary line dispute or a dispute of some type of encroachment or overlapping improvement or anything else listed above, if there's a issue with that, they have the opportunity to file an insurance claim with the title insurance provider and let them pick it up and have their attorneys kind of run with it should that claim have any merit to it. I will speak from personal experience that I have had a rental property where we opted for this coverage, and we had this exact situation pop up where there was a dispute between the neighbor and our property about where the boundary line was, because in reality there were 2 different surveyors, both from the same area. One marked stakes on 1 foot onto his property, one marked 1 foot of stakes onto our property, and there was some confusion there. He opted to sue me, okay, for that piece of property, and all I had to do was file a title insurance claim and let the title insurance company handle it for me. I didn't have to pay any money out of pocket. I didn't have to hire an attorney. They took care of it as if it was any other claim with insurance. Now, that may not be the standard result for everybody, but it is an example of why it's important to have this coverage. So I recommend in all circumstances that you opt to select 8.2, all right, and amend that section to read shortages in area. And I usually recommend my buyers do it at their expense, but you are more than welcome, if your buyer wants to try and get the seller to pay for it, to have them do that. So that is 6A. That covers the standard exceptions. Let's go ahead and jump into section B, which talks about the specific commitment. So 6B commitment states, within 20 days after the title company receives a copy of the contract, seller shall furnish to buyer a commitment for title insurance, commitment, and, at buyer's expense, legible copies of restrictive covenants and documents evidencing exceptions in the commitment, exception documents, other than the standard printed exceptions. Seller authorizes the title company to deliver the commitment and exception documents to buyer at buyer's address shown in paragraph 21. If the commitment and exception documents are not delivered to buyer within the specified time, the time for delivery will be automatically extended up to 15 days or 3 days before the closing date, whichever is earlier. If the commitment and exception documents are not delivered within the time required, buyer may terminate this contract and the earnest money will be refunded to buyer. So let's start from top to bottom. So the first thing is this: 20 days is the time frame for the seller to furnish the buyer a commitment for title insurance. So there's a little misnomer out there that if the title company takes a little bit too long to get the title commitment out, or they're behind, or for some other reason it doesn't get put out, that's okay, it's not a big deal, that's the responsibility of the title company. And while they're the ones that complete and issue the title insurance and the commitment, it is the responsibility of the seller to furnish it to the buyer. So in most circumstances, this isn't a big deal. If you don't make the 20-day deadline, as it states, you get a 15-day extension to do that, or 3 days before closing, whichever is earlier. So if you are on a 30-day close and you miss your 20-day mark, you have up till the 27th day to get that title commitment out to the buyer in order to be in compliance with the contract. If it comes out the 28th, 29th, or 30th day, the buyer can walk away from the transaction if they want to, and the earnest money will be refunded to them. This is very important for those of you that have buyers. The title commitment is what's going to give your buyer information on what they can and cannot do with the property. It could include deed restrictions. It could include some type of overlay restrictions. It could be HOA documents or restrictions. All that different stuff that's going to restrict what they might be able to do with the property is going to be delivered inside of that title commitment. Same thing with setback lines, utilities, and all that kind of stuff. All that stuff will be contained in there, and it's really important that they get it. And it's really important for us as agents and brokers to learn how to read through a title commitment so we can explain it to our buyers so they understand what it is they're getting into. So that summarizes this section. It's pretty quick. 20 days to deliver the title commitment. If it doesn't get delivered, you get an automatic 15-day extension or an extension to 3 days before closing if closing is 35 days or less. All right, so moving on, let's go ahead and talk about the survey. This section 6C states survey. The survey must be made by a registered professional land surveyor acceptable to the title company and the buyer's lender. And then we have 3 options below. Number 1, within blank days after the effective date of this contract, seller shall furnish to buyer and title company seller's existing survey of the property and a residential real property affidavit promulgated by the Texas Department of Insurance, the T47 affidavit. If seller fails to furnish the existing survey or affidavit within the time prescribed, buyer shall obtain a new survey at seller's expense no later than 3 days prior to the closing date. If the existing survey or affidavit is not acceptable to title company or buyer's lender, buyer shall obtain a new survey at seller or buyer's expense no later than 3 days prior to closing. Number 2, within blank days after the effective date of this contract, buyer shall obtain a new survey at buyer's expense. Buyer is deemed to receive the survey on the date of actual receipt or the date specified in this paragraph, whichever is earlier. Or we have number 3, within blank days after the effective date of this contract, seller at seller's expense shall furnish a new survey to buyer. So let's go ahead and break this down. So from the top, the survey has to be completed by a registered professional land surveyor, and that survey has to be acceptable to both the title company and the buyer's lender. In my experience, I would say it's 50-50 on whether or not the lender has a different overlay other than with the title company. Generally, half the time, if the title company is good with the survey, the buyer's lender will be good with the survey. And the other half of the time, the title company might be okay with it, but the buyer's lender might take some exception to something that's on the survey. Either way, the requirement is that it's approved and acceptable to the title company and the buyer's lender. Now, check box 1, within blank days. So within a certain number of days, the seller will furnish to the buyer and the title company the seller's existing survey of the property and a residential real property affidavit promulgated by the Texas Department of Insurance. So I usually place 5 days in here. If there's a survey and it's available, it should have been available prior to listing. So I'll put 5 days in here. That's my go-to. There may be circumstances where you talk to the listing agent ahead of time and they give it to you before. So maybe you just put 1 day in there. Maybe they say the seller is looking for it. They know they have it. It's just going to take them a week or two to find it. So you can put whatever number of days your buyer wants in here. I usually advise 5 days. That's essentially almost 1 week to go ahead and send me the docs. It's important to recognize here, and this is a mistake I often see listing agents make, is that you have to provide the survey and a T47 affidavit. Now, if you don't provide both, then the next bolded sentence kicks in. If the seller fails to furnish the existing survey or affidavit within the time prescribed, buyer shall obtain a new survey at seller's expense no later than 3 days prior to closing. So if you just provide the survey to the buyer's agent or to the buyer and not the affidavit, they can order a survey and your seller is going to be stuck paying for it whether they want to or not. Or if you provide a T47 that's not executed appropriately, you might as well not even provide it. The T47, okay, the affidavit, is a Texas Department of Insurance form, and it has to be notarized. It can't be DocuSigned or DigiSigned or any other type of digital signature. It has to be notarized, and it has to be filled out correctly. So it's outside the scope of this video to explain the ins and outs of a T47 affidavit, but just know it has to be done filled out appropriately, it has to be notarized, and you have to provide both that and the survey to the title company and the buyer within the number of days prescribed in checkbox 1. And if you don't, the buyer can order a new survey and it's going to be at the seller's expense. Now, say that you provide the survey and the affidavit and one or the other is not acceptable to the title company or the lender. If that's the case, the next sentence is what we're discussing here, the last sentence of checkbox 1. You get to negotiate up front who's going to pay for a new one, because if it's not acceptable to the title company or to the lender, they're not going to make the loan or they're not going to issue the title policy. Therefore, no purchase. All right. So you get to negotiate which one of the principals is going to pay for it. There's really no standard for this. Some people think the seller should pay for it because it's their property and they should have had one from the get-go. Some people think the buyer should pay for it because really that new survey is only going to benefit the buyer. However you decide to do it, it is going to be an added cost that you all are going to have to pay up front or at closing depending on your surveyor. And so this will really just be a discussion with your client. It will depend on the types of funds they have available to them and what other items you're negotiating in the contract. Generally, I will tell my buyers if there's no other, nothing else that we're trying to get, let's try and get the seller to pay for it. But if we're in multiple offers or my buyers got some other requests that are fairly important to them, I will let them know, hey, why don't you go ahead and just pay for it. That way, if you need anything in the future, you already have an existing relationship with the surveyor. Again, no rhyme or reason about why you do one or the other. It's going to depend on your circumstances. So if there's no existing survey, though, or the one that you have is no good or it's not going to fly, maybe it's 40 years old, all right, you have checkbox 2 and checkbox 3. In either one of these, it's essentially the same thing. It's just who's going to pay for it. If the buyer says, you know what, I'll pay for a new survey since we don't have one or the one we have isn't good, you can just check box 2. If you're trying to get the seller to pay for it, the seller's like, you know what, I'll pay for one because I can't find my old one, you're just going to check box 3. Now, the number of days that you place in either one of those boxes is going to be up to you. And generally, I would say that you want to order that as quick as possible if you don't have one. So I would generally put 5 days in there, just like I would in checkbox 1, so that we can get that ordered. In certain areas, surveys could take up to a month to get, and so you don't want to be waiting till 20 days into your escrow period to order that, because it may cause your closing to be delayed, and you just kind of want to try to avoid that. So that is the survey section. If you have any questions about anything here in B or C, you can post them down below, and I'll go ahead and address those the best I can. Let's go ahead and move on to Section D, objections. So Section D, objections, reads as follows. Buyer may object in writing to defects, exceptions, or encumbrances to title disclosed on the survey other than items 6A1 through 7 above, disclosed in the commitment other than items 6A1 through 9 above, or which prohibit the following use or activity, and there's a blank present. Buyer must object to the earlier of the closing date or a blank number of days after buyer receives the commitment, exception documents, and the survey. Buyer's failure to object within the time allowed will constitute a waiver of buyer's right to object, except that the requirements in Schedule C of the commitment are not waived by buyer. Provided seller is not obligated to incur any expense, seller shall cure any timely objections of buyer or any third-party lender within 15 days after seller receives the objections, cure period, and the closing date will be extended as necessary. If objections are not cured within the cure period, buyer may, by delivering notice to the seller within 5 days after the end of the cure period, terminate this contract and the earnest money will be refunded to the buyer, or waive the objections. If buyer does not terminate within the time required, buyer shall be deemed to have waived the objections. If the commitment or survey is revised or any new exception documents are delivered or is delivered, buyer may object to any new matter revealed in the revised commitment or survey or new exception documents within the same time stated in this paragraph to make objections beginning when the revised commitment, survey, or exception documents are delivered or is delivered to the buyer. So, what does this whole paragraph mean? This paragraph gives our clients the ability to object to something that prevents them from doing something that they want or something that they prefer not to be a part of the property once they take possession. So this could be some type of restriction. This could be some type of boundary line that prevents them from doing something they want. It could be some type of use. Any of those things are things that the buyer can object to because it prevents them from doing something they want or creates a overbearing or a restriction that they just don't want to deal with. So let's start from the top. So first things first, this objection has to be done in writing, and they can object to defects, exceptions, or encumbrances to title. It has to be on the survey or disclosed in the title commitment or through some other exception. Now, the very first blank reads, or which prohibits the following use or activity, and then there's a blank, is your buyer's opportunity to place something that's important to them inside of that blank that would not be a standard exception. So for example, let's say that your client wanted to build multiple homes on a piece of property. So they may put construction of 3 or more or multiple, depending on how you want to word it and how your client wants it, residential structures. Or say they wanted to park a RV that's at least 45 feet long. So, or they want to keep their boat on their property, or they want to operate a business out of their property. There's a variety of things that could be important as far as use or activity goes that would be important to your buyer, and that's where you should place these items. Now, it is common, and I've seen this very often, where people like to put residential use or something like that inside of this space. Now, generally, if you're purchasing a single-family residence on a residential contract like this, residential use is inferred. That being said, there certainly could be times where a buyer is purchasing a home as a single-family residence but resides in an area where perhaps single-family occupancy is no longer allowed. So for example, in a downtown or a business district where zoning only allows for commercial activity, but they're buying a old home or a historic home in that area and they want to actually live in it, not run a business out of it, that would be an example where residential use would be an appropriate thing to list here, because if zoning prohibits that or is no longer allows it, they're able to back out of the contract. All right, so this is going to be a spot where you're able to add things like that. Residential leasing or tenants may also be another common one you might put in there if they're going to use the property for leasing. If there's some type of restriction or overlay that prevents them from leasing the property, that would give them the ability to back out. So that's where you would list those. The next blank talks about how long you have to object. So you have up to the day of closing or a certain number of days after you receive all the documents. as a buyer's agent, the number of days within that blank you want to put as far out as possible. As a listing agent, you want it to be the least number of days possible. I generally find that 5 days is a pretty good in between number where it's enough time for somebody to review, but it's also enough time where you're not, sitting on the market, you're not sitting under escrow for an extended period of time where the buyer can just back out randomly before closing. Now, one thing that's important to remember is that this clock starts when you receive the title commitment, the exception documents contained in that commitment, and a copy of a acceptable survey. So if you get the commitment and the exception documents, but you're waiting on a new survey to come in, this time or this clock does not start until you have all of those. So once you get all of those clocks, that clock starts. If you don't object within the required time frame, your buyer is waiving any exceptions that they might be able to take to any of those documents. All right. Now, if they decide to object to something, so say they object to a certain restriction or overlay, or there's some other issue, if the seller is able to cure that or to remove that issue, they have 15 days to do it. That period of time, that 15 days, is defined as the cure period. So once you make that objection, they get 15 days to do that. Now, the contract states that the closing date will be extended as necessary. Now, this is one of those areas of the contract where I think the broker-lawyer committee in the future will probably try to narrow down a little bit more specifically, because it doesn't state how long it's going to be extended. Is it extended 15 days? Is it extended 30 days? Is it 20 days? I mean, there's a lot of different numbers you could make up out of everything that's contained in this paragraph and other parts of the contract. And so all it states is that the closing date will be extended as necessary. And so a little bit of a subjective thing there. I don't really like it, but it is what it is. If you have questions about this or you're not sure, you want to make sure and call your broker. You want to make sure and talk to a real estate attorney and get clarification for each individual situation, because each one's probably a little bit different. So if that 15 days goes by and the seller is not able to cure the objection or get the objection, get rid of it, the buyer has two options. They can either terminate the contract at that point and get their earnest money back, or they can waive the objection. So they made the objection, it's not able to be cured, and so they can waive the objection and carry on. If the buyer does not terminate within that 5-day period after the 15 days is over, it is assumed that they are waiving the objection and the sale can continue on. All right. Now, it's not uncommon for especially on a 30 or 45-day closing, to have the title commitment, exception documents, and survey all out within probably the first 2 weeks if everybody has everything they need like they're supposed to. And that's great. But what happens if during the escrow period something is revised? Well, if something is revised, let's just say the underwriter for the title company noticed an issue with the survey, and so they have to get a new one, or something that wasn't initially discovered pops up and they revise the commitment, or the exception documents change, or they missed one. If something changes, all these time periods start over. Once you receive the updated title commitment, the survey, or exception documents, that period of days that you gave yourself above in the beginning of this paragraph, that starts over, and you get another however many days. So let's just say it's 5 days. You get another 5 days to review those and to provide objections, and all of these time periods will start over once you get those new documents in hand. So that is the objection section. Let's go ahead and close out. And again, as always, if you have any questions, feel free to post them below. Let's move on to title notices, which is a fairly long section. So the title notices section has 10 different notices that are required to be provided or need to be provided to buyers, either as a part of statute or as a requirement under some other area other than the property code. And so that's where you'll find these. So the very first one is the abstract or title policy. Now, this is a notice that's required under TRELA for brokers to provide to buyers to make sure that they get their title policy examined or get a policy of title insurance. So this particular section states, number 1, abstract or title policy. Broker advises buyer to have an abstract of title covering the property examined by an attorney of buyer's selection, or buyer should be furnished with or obtain a title policy. If a title policy is furnished, the commitment should be promptly reviewed by an attorney of buyer's choice due to the time limitations on the buyer's right to object. So this goes in line with our previous review of Section D, in that once a title commitment comes in, the buyer is now being advised per the contract to have an attorney review that as quickly as possible, because there are limitations to their ability to object to it. It's pretty straightforward notice for E1. The next section is Section 2, Membership and Owners Property Association. The Membership and Property Owners Association reads as follows. The property is or is not, you select the box, subject to mandatory membership in a Property Owners Association. If the property is subject to mandatory membership in a Property Owners Association, seller notifies buyer under 5.012 Texas Property Code that, as a purchaser of property in the residential community identified in paragraph 2A, in which the property is located, you are obligated to be a member of the Property Owners Association. Restrictive covenants governing the use and occupancy of the property, and all dedicatory instruments governing the establishment, maintenance, or operation of this residential community have been or will be recorded in the real property records of the county in which the property is located. Copies of the restrictive covenants and dedicatory instruments may be obtained from the county clerk. In nice big bold print, underlined, it also states, you are obligated to pay assessments to the Property Owners Association. The amount of the assessments is subject to change. Your failure to pay the assessments could result in enforcement of the association's lien on and the foreclosure of the property. Section 207.003 Property Code, that's the Texas Property Code, entitles an owner to receive copies of any document that governs the establishment, maintenance, or operation of a subdivision, including but not limited to restrictions, bylaws, rules, and regulations, and a resale certificate from a Property Owners Association. A resale certificate contains information including, but not limited to, statements specifying the amount and frequency of regular assessments and the style and cause number of lawsuits to which the Property Owners Association is a party, other than lawsuits relating to unpaid and ad valorem taxes of any individual member of the association. These documents must be made available to you by the Property Owners Association or the association's agent on your request. And then in bold print it states, if buyer is concerned about these matters, the TREC promulgated addendum for properties subject to mandatory membership in a Property Owners Association should be used. So fairly straightforward. Let's go back and talk about it. So if a property is subject to membership in a property owners or HOA association of some kind, you need to mark that it is subject to all of these items. That is notifying the buyer that they are subject to all these things mentioned inside of this particular section. If it is not, you mark is not, and then this section for the most part does not apply. Now, you are allowed and entitled to, as a buyer, to receive all the information contained inside of this paragraph. But it is of special note, and that's why it's bolded and underlined, that the buyer is made aware that they have to pay assessments to the Property Owners Association, that those can change, and if you don't pay, the HOA or the Property Owners Association can file a lien against your property and foreclose and take that property from you. So that's why it's a nice big bold underlined print. In addition to that, if there's an HOA, you get a resale certificate. All of these things, although it says can be obtained at the county clerk's office, these will usually come from title along with the title commitment. It may take them a little longer to get some of these things, and so the title commitment might come out first, but you'll always get a copy of these. And if you're not getting a copy of these from the title company, you need to make sure and ask them where they're at, have they been ordered, so on and so forth. Now, I'd also like to point out that at the bottom it says in bold, if the buyer is concerned about these matters, to use the addendum. I would encourage you to always, 100% of the time, if a property is in an HOA or Property Owners Association, use the appropriate addendum, which is the addendum for property subject to mandatory membership in a Property Owners Association. Always use that, fill it out appropriately, and make sure you get those documents for your buyers. It's a little beyond the scope of this video to go over that particular addendum and the ins and outs of that, but we'll do that on a later video. So that is the Membership in Property Owners Association section of the title notices. Moving on, we have number 3, statutory tax districts. Now the statutory tax districts paragraph basically informs the buyer that they could be situated inside of a utility or other statutorily created district that provides some type of service to them, and that they may be taxed as a part of that. There may be fees associated with that. So this section reads as follows: statutory tax districts. If the property is situated in a utility or other statutorily created district providing water, sewer, drainage, or flood control facilities and services, Chapter 49 Texas Water Code requires seller to deliver and buyer to sign the statutory notice relating to the tax rate, bonded indebtedness, or standby fee of the district prior to final execution of this contract. Each separate district has their own form, or should have a form that you can sign and fill out. If not, check with your local association. They should have one that you can review and use too if you need it. But make sure that you're providing that as appropriate. If not, it is a way for the buyer to get out of the contract. So it's something on the selling side you want to make sure and look out for. The next section, number 4, is tidewaters. That reads as follows: if the property abuts the tidally influenced waters of the state, 33.135 of the Texas Natural Resources Code requires a notice regarding coastal area property to be included in the contract. An addendum containing the notice promulgated by TREC or required by the parties must be used. So, if your property, or if the property that you're listing abuts a tidally influenced waters of the state, so basically our coastal areas, right, then you need to provide the appropriate addendum for notice that's promulgated by TREC for this particular item. Again, one thing that's outside the scope of this video and will be discussed in a future video. The next section, section 5, discusses annexation. This is basically notice to the buyer that at some point their property may be annexed into a municipality, and that they would be subject to all the taxing and everything else that goes with that. I would imagine that in the near future, and this is being recorded in October of 2019, I would imagine in the near future this section might change a little bit, only because cities have lost the ability to unilaterally annex property at this point. They must do so via a vote of the people that are going to be annexed. So I would guess this might change in the near future. I could be wrong, but keep an eye out for it just in case. This section reads as follows: annexation. If the property is located outside the limits of a municipality, seller notifies buyer under 5.011 of the Texas Property Code that the property may now or later be included in the extraterritorial jurisdiction of a municipality, and may now or later be subject to annexation by the municipality. Each municipality maintains a map that depicts its boundaries and extraterritorial jurisdiction. To determine if the property is located within a municipality's extraterritorial jurisdiction, or is likely to be located within a municipality's extraterritorial jurisdiction, contact all municipalities located in the general proximity of the property for further information. Moving on, we have the property located in a certified service area of a utility service provider. Oh, that's a mouthful. It reads as follows: notice required by 13.257 Water Code. The real property described in paragraph 2 that you are about to purchase may be located in a certified water or sewer service area, which is authorized by law to provide water or sewer service to the properties in the certificated areas. If your property is located in a certificated area, there may be special costs or charges that you will be required to pay before you can receive water or sewer service. There may be a period required to construct lines or other facilities necessary to provide water or sewer services to your property. You are advised to determine if the property is in a certificated area and contact the utility service provider to determine the cost that you will be required to pay and the period, if any, that is required to provide water or sewer service to your property. The undersigned buyer hereby acknowledges receipt of the foregoing notice at or before the execution of a binding contract for the purchase of the real property described in paragraph 2, or at closing of purchase of the real property. So again, this is a notice, so you need to make sure that the property that your buyer is buying, all right, has utilities to it, and if they don't, and they need to be provided, this is your chance to go and figure out the cost of doing that, if there's going to be a delay in doing that, and all those things that could be surrounding the area, how much it's going to cost and whatnot. So again, part of making sure that your property has appropriate utilities, that's going to be a buyer due diligence thing. We want to make sure that our buyers are doing that. Moving on to section 7, public improvement districts. It reads as follows. If the property is in a public improvement district, 5.014 of the Texas Property Code requires seller to notify buyer as follows. As a purchaser of this parcel of real property, you are obligated to pay an assessment to a municipality or county for an improvement project undertaken by a public improvement district under Chapter 372 Local Government Code. The assessment may be due annually or in a periodic installments. More information concerning the amount of the assessment and the due dates of that assessment may be obtained from the municipality or county levying the assessment. The amount of the assessments is subject to change. Your failure to pay the assessment could result in a lien on and the foreclosure of your property. So in certain areas of Texas, in order to create either improved infrastructure, utility delivery, all those different kind of items that you need, they can create a public improvement district. It is a taxing entity for all intents and purposes, and so there may be fees. Usually, when I say it's a taxing entity for intents and purposes, it's not an actual taxing entity, but you do pay fees to that public improvement district, the PID, and those fees may or may not be collected with your taxes, with your escrow, and so you just need to be careful figuring out how much those fees are going to be, how much you're going to owe for those, how they're collected, so on and so forth. But again, this is providing notice that you may be in one of these areas, and if you don't pay the assessments, they can file a lien and foreclose on your property. Number 8, transfer fees. If the property is subject to a private transfer fee obligation, 5.205 Property Code requires seller to notify buyer as follows. The private transfer fee obligation may be governed by Chapter 5, Subchapter G of the Texas Property Code. So again, just informing the buyer that if there are transfer fees, they're going to have to pay them and where they're governed. Number 9, propane gas system service area. If the property is located in a propane gas system service area owned by a distribution system retailer, seller must give buyer written notice as required by 141.010 Texas Utilities Code. An addendum containing the notice approved by TREC or required by the parties should be used. So again, we have a notice for this that's issued by TREC. There is a website, and I'll see if I can find it, and I'll post it on the screen. In fact, if you look at the screen right now, it'll be posted off to the side. That is where you can go to figure out whether or not the property is located in one of the handful of propane gas system service areas in the state of Texas. If you're listing, you need to make sure that you are able to verify whether it is or is not. And if you're a buyer or a buyer's agent, you need to make sure that you're getting the required notice right at contract time. The last notice is number 10. It's notice of water level fluctuations. It reads as follows. If the property adjoins an impoundment of water, including a reservoir or lake, constructed and maintained under Chapter 11 Water Code that has a storage capacity of at least 5,000 acre-feet at the impoundment's normal operating level, seller hereby notifies buyer, quote, the water level of the impoundment of water adjoining the property fluctuates for various reasons, including as a result of 1, an entity lawfully exercising its right to use the water stored in the impoundment, or 2, drought or flood conditions. This is simply a notice that, hey, if you live on a body of water, that body of water could go up, it could go down, it could flood, it could dry up, but just be aware that the amount of water there could change. So this concludes our review of paragraph 6 of the 1-to-4 residential sales contract resale. So it's a long section. It was one single video. We're almost at about 45 minutes for this video. I appreciate you watching. If you have any questions, please post them below. A lot of detailed stuff, a lot of notices in here, and a lot of ins and outs of this part of the contract are good for buyers getting out of the contract, and following them is a good way for listing agents and sellers to keep buyers inside of the contract. So make sure you're familiar with them. Go back and watch a particular section if you need to again. And as always, appreciate you listening. Have a great day.